I'm sorry that we're not able to do this live together. As you may have noticed in your email, I've had a bit of a day. So I apologize for that, but here is our last lecture covering new material of the semester. On Monday, our class will not meet because of the Easter bank holiday, and on Wednesday we'll be doing a revision session. So this is going to cover everything else that you need to finish out the class, and then we're going to be done. So we're going to be covering two things today. First, we're going to cover false imprisonment, and then we're going to cover defenses. Okay, so false imprisonment requires two elements in order to be proven. You have to restrain the person of the plaintiff, and you have to have no sort of lawful imposition. In other words, the restraint has to be wrongful. Okay, and when we look at the cases, there's largely four things that sort of determines the outcomes of the cases. Okay, the first one is, was the plaintiff actually in fact restrained? The second one is, did the plaintiff know that they were restrained, and does that matter? Third is, did the defendant use force, and does that matter? And finally, is there some sort of lawful condition here that makes it so that the restraint was not in fact wrongful? So turning to the first issue on restraint, right? We know that the plaintiff has to actually be prevented from moving about. It's not just enough that the defendant says you can't come onto this piece of property, you have to go around, right? The plaintiff has to actually be prevented from going where they want to go. And it has to be some sort of, you have to think of it in terms of, it has to be an imprisonment, not an exclusion. And that comes from the Bird versus Jones case, and that's where a bridge owner had blocked off the bridge in order to provide it as a spectator space for an event on the water, and they prevented the plaintiff from using the bridge as a bridge. The next element, like the next component of the restraint issue that we know, is that just because you want to exit in a particular way or from a particular direction or through a particular door doesn't mean that the defendant is required to oblige you. Okay, you have not been falsely imprisoned if the defendant will not allow you to leave through the employee's only door. Okay, right? You'll recall from the Robinson versus Balmain New Ferry case that was a situation where once you entered the defendant's property, you paid your fare as a ferry operator. You paid your fare when you entered the property on one side of the river, and if you entered from the other side, if you boarded the ferry from the other side of the river, you paid your fare upon exit. And so the plaintiff had attempted to enter and then exit without taking the ferry across the river. And they said, no, if you want to leave, you have to pay again. And he was unhappy about this, and the court concluded that there was no false imprisonment because you were free to leave, you just had to board a ferry and cross the river to do it. If you wanted to leave on the same side of the river as where you had paid to enter, you had to pay to exit. And finally, if you have agreed to limit your freedom to a particular time, then the defendant is under no obligation to afford you the exit prior to the time that they've agreed to. So if you've agreed to be locked in for 8 hours, well, until your 8 hours are up, well, there you can stay. As long as once the 8 hours are up, you are in fact released. But the key piece of this, right, the thing that's important to keep in mind is that the restraint doesn't have to be in a jail cell or in a windowless hole. It just has to be you are not allowed to leave where you are, right? And where you are can be defined quite broadly. It can go from, the small office of the store manager all the way up to, an entire complex of buildings and coal mines and whatnot. So those are the issues that relate to restraint. Next, we have to talk about knowledge. Now, one of the things that is different between the United States and the Commonwealth, but in particular the UK, is that the United States requires that the plaintiff actually know that they've been restrained. Okay, so in the United Kingdom and the Commonwealth more broadly, if you set up a restraint on the plaintiff, they never find out that it was there, and then you remove it and allow them to go about their business, and they never actually knew that they were restrained, if it was unlawful, you have still committed the tort of false imprisonment. Okay? But one of the points that their lordships make in Murray versus Ministry of Defense is that if you're not aware of a restraint, there may not be more than nominal damages that are attached to it, right? We may be talking about $1, or in the UK, right, a shilling, being sort of the traditional measure of nominal damages. When we talk about this in practical terms, right, how does this affect actual cases that you will be litigating as lawyers? The question of whether the plaintiff was restrained when they weren't aware of it is really only going to affect how long a plaintiff was restrained for. And this is relevant for damages, right? The longer that you're restrained, the more your damages are. Even if they're nominal, they're going to start to pile up, right? There's going to come a point where the court says, okay, now this is 2 shillings worth of restraint, right? However long that may be, which is up to the court. Because if you think about it, if you place a restraint on a plaintiff, if you prevent them from moving around and they never know and they never find out and they never test it, how can they name their injury and assert that they have any sort of claim, right? I don't know. This is sort of the logic of why the United States requires that plaintiffs be aware of the fact that they were restrained. And the worksheet sort of criticizes this requirement. It says that it alters the logic of the intentional tort, right? Intentional torts are intended to not involve questions of damage, but rather they are actionable per se. So the fact that the tort was committed is sufficient to prove liability. There's no need to show actual harm. In the United States, that's not the case. For false imprisonment, you have to show harm. I am not sort of here to opine on these differences. I note that they exist, and I think that that's something that you may want to keep in mind as you continue to revise and prepare for the exam. The third thing that we want to talk about is force, right? Obviously, if the defendant sort of, prevents the plaintiff from leaving through the use of force, right, through the use of, physical power, that's clearly a restraint on the plaintiff's movement. But it is less clear when all the plaintiff does is, when all the defendant does is exercise authority, right? Say, oh, you have to come with me because I'm a police officer, or you have to come with me because I'm a security guard, right? And those cases are closer. So one of the things that the courts are sort of unanimous about is that if the plaintiff was in fact coerced, then the force element exists, right? The restraint exists. If all that was done is that the plaintiff was sort of invited to come along with the defendant, and they were never required to go where the defendant wanted them to go, then that's not a restraint. There's no false imprisonment. One of the things that we tell, that American lawyers tell their clients to say to the police is, officer, am I free to go, or am I being detained? Because in the United States, if you're just sitting there talking to a cop, well, you don't have any sort of constitutional rights there, right? You don't have any rights. The cop can talk to you about anything they want, and anything you say can be connected to anything else the cop knows, and you may find yourself arrested without really thinking about it. But if you ask the cop, am I free to go? Then if he says no, you've been detained, and that invokes certain rights. And similar to this, right, this digression is not without a point. Similar to this, if you ask law enforcement in the Commonwealth, officer, am I free to go? Then when the officer says no, you have been restrained. And if that restraint was done unlawfully, then you can assert a claim for false imprisonment. Okay? My lecture notes give you some more information about the American process if you are interested in that, but that's not really something that we're going to talk about. And the last piece of the false imprisonment case is the question of whether the defendant acted unlawfully. Okay? And the ultimate question that we're asking is, what is the basis for the defendant to detain the plaintiff? And we're not going to do a deep dive on this. There's lots of bits and pieces of this. The textbook gives you a fairly lengthy explanation on this, as does the worksheet. I'm going to go ahead and tell you that this is not something that is going to matter for your success in this course. So you only need to know it for the purpose of being ready for torts 2. One of the key differences in the lawfulness inquiry is that law enforcement has broader powers than private citizens, right? Private citizens do have some power to detain you under certain circumstances, but one of the major differences is that if a private citizen, including a security guard, detains you, right, detains a plaintiff, that private citizen has to be able to produce evidence that an offense was actually committed. They have to be able to show, oh yes, a crime actually was committed, not just, oh, we think a crime was committed. Law enforcement has a little more discretion here. Law enforcement can detain someone while they attempt to determine whether a crime was committed. Okay? And there are a number of other differences that sort of all boil down to law enforcement has discretion that private citizens do not. Okay? So that is false imprisonment. The next thing that we're going to talk about are the defenses, right? To sort of work backwards, right? False imprisonment, the key defense is, look, I had a lawful basis for this detention. Okay? We've discussed that already. For battery, there are several defenses that matter. The most important one, I think, is consent. Right? So consent is an element of the plaintiff's case, so that they have to prove the lack of consent. But even if they prove a lack of subjective consent, the defendant can make a showing that a reasonable person would have seen the situation as manifesting consent. So, for example, right, consider a medical procedure. A patient consents to the procedure, it's correctly done, but there are side effects that they weren't expecting. So did they consent to it, or were they the victim of a battery? And if you read the Chatterton versus Gerson case, you'll know that they have in fact consented to the trespass, and so there's no claim. The next defense is, well, it's self-defense. And it pretty much speaks for itself. You can, if someone is attacking you or is invading your property, you can use force to defend yourself, but that force has to be responsive, so no bear traps. It has to be preventive rather than punitive, so once you've driven the trespasser off, you're not allowed to keep shooting. And it has to be proportionate. Okay, it has to be proportionate. So if someone bumps into you during crop over, you're not allowed to take a knife and cut their arm off. Right? That's not how this works. The next three defenses are all sort of connected, so I'm going to talk about them together. And that's provocation, contributory negligence, and illegality. Okay? And basically, the idea behind all of these defenses is that the plaintiff did something wrong to trigger the trespass. Okay? And sort of the cases that talk about these defenses a lot of times involve like street fights, people who get mad at each other and they get into a fight with one another, and without sort of doing a deep dive on this, which is not really worth your time, you don't have to worry about it too much. But the key pieces of this are that provocation, right? The idea that you can be provoked into striking someone or committing an assault or battery. The courts have pretty unanimously held that provocation doesn't affect liability, and it doesn't affect damages that can be calculated or general damages, but it can prevent the plaintiff from recovering punitive damages. So if you have a case where punitive damages or aggravated damages may be on the table, showing a defense of provocation that no reasonable person wouldn't have hit the defendant could lead to a reduction in the damages that the plaintiff owes. Contributory negligence is treated similarly, and the truth is, I haven't seen a case that makes a good explanation of what the distinction between the two is. And the other sort of odd thing about contributory negligence is that the textbooks talk about it, they talk about it in the sense that they note that a couple of cases have suggested that you could assert contributory negligence as a defense to a battery claim or to other trespass claims. But there's not any cases that have held that it should be successful on a given pattern of facts. So, if a defense sort of exists in theory, but there's no set of facts that will actually prove it, does it really exist? I don't think so. And finally, illegality. The problem that I have with illegality as a defense, and you'll recall this from our discussion on defenses to negligence, is that if you are engaged in a criminal enterprise, torts that arise from the crime are not actionable. And the question that I sort of come back to as I think about this is, are the people who are fighting each other engaged in a joint criminal enterprise? I mean, certainly they are both committing a crime, right? They are both committing a breach of the peace. But is it joint? I mean, certainly if they weren't both participating, the fight wouldn't exist, but I mean, I don't feel like I have a great way of articulating why I'm uncomfortable with this, but I hope that you guys can understand the discomfort here. If you don't understand it, reach out. We're happy to, we can chat about it in more detail. But the final defense to trespass claims is necessity. And necessity, and boy, I think my torts class had like a lot of discussion of necessity, but we're going to do it very briefly. But basically, sometimes you don't have an opportunity to obtain consent to a particular trespass. This is very common in emergency medical treatment, but other circumstances as well, right? Pushing someone out of the way of a speeding vehicle, rescuing someone from rising floodwaters. There's a lot of different reasons why someone might not be able to consent to a trespass, but you still, you gotta touch them, okay? And so what the law says is that if the plaintiff would reasonably have consented had they been able to, then the fact that the consent was impossible to obtain would allow the defendant to treat it as if it was consented to. So let me explain that again, maybe a little bit differently. So you're not able to obtain consent, but had you been able to, a reasonable person in the plaintiff's position would have consented to the trespass. Then the court says this is as good as consent. Okay? So that's everything. Guys, this has been a very difficult semester for all of us. But I have recognized at every step how you guys have been dogged about pursuing your learning and making sure that you are engaged with the material. And I appreciate that, and I have noticed that. So it has been my pleasure and my honor to be your lecturer this semester. I look forward to repeating the experience with you next semester with real property. I don't claim that all of you are going to be as excited about real property as you are about torts, more's the pity, but we will do our very best to have a good semester, and hopefully we'll have it in person. Hopefully we'll all get to see each other for real. So L'Shana Haba'a B'Cave Hill, next year in Cave Hill. So, take care, guys, and we'll continue to be in touch as the semester finishes up.